In the matter of DAIVSHALA versus Oriental Insurance Company Limited, Supreme Court allowed the appeal and set aside judgment of High Court of Judicature at Bombay Bench at Aurangabad. Court said that considering the deceased was a night watchman and was dutifully proceeding to his workplace to be well on time, there was clear nexus between the circumstances, time, and place in which the accident occurred and his employment as a watchman. Shahu Sampatrao Jadhavar was employed as watchman in respondent number 2 sugar factory. His duty hours were from early morning 3 a.m. to 11 a.m. On 22nd April 2003, he left home on motorcycle to report for duty. However, unfortunately, he never reached his place of work. When he was 5 kilometers away from factory, his motorcycle was involved in a fatal accident. He left a large family behind, a widow, 4 children, and his mother. In a claim filed under Employees Compensation Act 1923, employer and insurance company set up the defense that accident had not arisen out of or in course of his employment, since the accident occurred outside precincts of the factory. Supreme Court took notice of the 62nd report of the Law Commission of India on the EC Act, which was submitted on October 1974 under chairmanship of Chief Justice retired P.B. Gajendra Gadkar. As rightly set out in report, the purpose of workmen's compensation laws was to eliminate hardship experienced under common law system by providing for payment of benefits regardless of fault and with a minimum of legal formality. The Law Commission report also discussed International Labour Convention of 1964 for compensation on way to work accidents. The high courts in India were also engaged with this issue about interpretation of the phrase arising out of and in the course of employment with regard to accidents occurring while proceeding to place of work by the employee. The words deemed to have used in section 51E is not in the context of legal fiction. It is well settled that expression deemed is sometimes used to impose for purpose of a statute an artificial construction for a word or phrase that would not otherwise prevail. Very often it is also used to put beyond doubt a particular construction that might otherwise be uncertain. Sometimes it is used to give a comprehensive description that it includes what is obvious, what is uncertain, and what is, in the ordinary sense, impossible. The question further remains whether assuming Section 51E is retrospective, would the interpretation flowing out of 51E of ESI Act be imported into EC Act to interpret the phrase accident arising out of and in course of employment to decide whether it will include accidents happening to employees while commuting to place of work and vice versa. The operative phraseology occurring in Section 3 of EC Act is same as one that it occurs in Section 2(8) of ECI Act, which defines employment injury. Secondly, as held by Supreme Court and as noticed above, both acts and beneficial legislations intended as social security measures to ameliorate the conditions of the employee. As rightly noticed by Chief Justice retired Gajendra Gadkar, in the 62nd Law Commission report, only difference between two statutes was that while ESI Act applies to factories and notified establishment, the Employee Compensation Act applied to other employers as defined. It is well settled that where statutes in pari materia serve a common object, in absence of any provision indicating to contrary, it is permissible for a court of law to ascertain the meaning of the provision in the enactment by comparing its language with other enactment relating to the same subject matter. In Justice G.P. Singh's principle of statutory interpretation dealing with statutes in pari materia, the following passage finds mention. Statutes in pari materia, it has already been seen that statute must be read as a whole, as words are to be understood in their context. Extension of this rule of context permits reference to other statutes in pari materia, that is, statutes dealing with the same subject matter or forming part of the same system. Viscount Simons, in a passage already noticed, conceived it to be a right and duty to construe every word of a statute in its context, and he used the word context in its widest sense, including other statutes in pari materia. As stated by Lord Mansfield, where there are different statutes in pari materia, though made at different times or even expired and not referring to each other, they shall be taken and construed together as one system and as explanatory of each other. In Cray's on Legislation, ninth edition, dealing with statutes in pari materia, has the following observation in para 20.1. Statutes in pari materia. Two acts are said to be in pari materia if taking all the circumstances into account. It is natural to construe them as if they form a part of a single code on a particular manner. Where this is found to be the case, result is that definitions in one may be applied to expressions found in another, and decided cases setting out principles of applications to one will be applied to another. The fact that two statutes have the same titles may be indicative of their being in pari materia. As Bridge LJ said in R versus Wheatley, looking at the two statutes, the Explosives Act 1875 and Explosive Substances Act 1883, at nature of the provisions which they both contain, and in particular at the short and long titles of both statutes, it appears to the court that clearly they are in pari materia, and that conclusion alone would seem to us to be sufficient to justify conclusion which the judge reached, that the definition of the word explosive found in 1875 Act is available to be adopted and applied in the provisions of 1883 Act. In the case of State of Assam and another versus Deva Prasad Barua and another, the Supreme Court, while construing Section 19 of Assam Agriculture Income Tax Act 1939, gave it the construction given to Section 22 of Indian Income Tax Act and held as under. Moreover, Section 19 is in perimeteria with Section 22 of the Income Tax Act, and the law which has been laid down by the court while interpreting the provisions of that section must govern the construction of the provisions of Section 19 as well. Applying the above principle, Supreme Court interpreted the phrase accident arising out of and in the course of his employment occurring in Section 3 of the Employee Compensation Act to include accident occurring to an employee while commuting from his residence to the place of employment for duty or from the place of employment to his residence after performing duty, provided the nexus between the circumstances, time, and place in which the accident occurred and the employment is established.